Hello, my name is Paul Cheng. I wanted to thank each and every one of you for being here today. I'm so excited for you. I'm excited for you because at the end of these 2 hours, you will be able to look at sexual harassment in a vastly different way, particularly if it relates to your business and your management. My name is Paul Cheng, and I have next to me, please introduce yourself.
Hi, everyone. This is Emery Lee from KCAL Insurance Agency. I am responsible for commercial insurance, workers' comp, and commercial auto insurance.
And for those of you that can't see Emery Lee, I would definitely recommend that you try to stop by KCAL Insurance. If anything, just to be able to meet her, I think you'll be pleasantly surprised, as well as the fact that she has a lot of knowledge to impart to you today in relation to sexual harassment. In regard to sexual harassment, we do have a PowerPoint available for you. You need to email KCAL Insurance. It will be available on the website. Why do we have a sexual harassment course? We think this is very important. In California, there is a requirement. A Senate bill was passed, as well as an Assembly bill, which relates to employers that have over 50 employees at a company. In having 50 employees at a company, there is a requirement that for every 2 years, your management team is required to have a sexual harassment course. Now, what ends up happening to an employer that decides not to do it? Well, in a sexual harassment lawsuit, it is presumed that your company doesn't have a good sexual harassment policy if you don't take a sexual harassment course. So I think that's one of the great things about KCAL Insurance and about being a client of KCAL Insurance. We want to make sure that this does not happen to you, and that we hope in having this sexual harassment course, you will be able to learn the ins and outs, and particularly your management team be able to present sexual harassment in a very logical and professional way. Now, Emery, let me ask you, sexual harassment, do you sell any type of policies related to sexual harassment? I know people talk a lot about EPLI, but I want this to be very important because some people think that workers' compensation actually covers sexual harassment. I don't know if it's true, and I'd like to know. Does workers' compensation cover sexual harassment?
No, workers' compensation insurance does not cover sexual harassment at all whatsoever. If it's work-related injury, of course, it falls under workers' comp. But if it's anything besides work-related injuries, such as sexual harassment or wrongful termination, there's another insurance for that, which a lot of people fail to realize that not having that coverage is very important. They think that having business insurance or workers' comp, that's basically all you need. A lot of people thought, okay, if I come into any incident with my employee, any lawsuits against my employee, they're coming to sue me for whatever reason, it automatically covers under workers' comp, which is not true. We really want to stress that workers' comp only covers if it's work-related injury. And by work-related injury, it doesn't have to be on your premises. It could be outside of your premises, for example. So that will also be covered, but it's not under workers' comp if it's non-related work issues.
Oh, okay. 好，没有问题。I think it's so important what Emery just mentioned, that a lot of people are very confused. And as an attorney for KCAL Insurance and as an attorney that actually meets a lot of both employers and employees, I would have to say that there's a lot of confusion. And I think Emery has hit it right on the dot, right on the head, which is that workers' compensation does not cover sexual harassment. I don't know if you know this, Emery, but only 3% of cases go to trial. 97% of cases across the United States, both criminal and civil, settle or are disposed of out of court. I don't know if you knew this. Did you know that?
No, I do not. I mean, I assume that everything that comes in, it will go to an attorney, because if it doesn't cover under workers' comp, we don't report to a workers' comp carrier, then of course the customer will have to hire their own attorney. Does it really settle out of court? We do not know that.
Yeah, so Emery is not going to know this, but Emery looks like she's just graduated out of high school. I still remember Perry Mason. So Emery, do you know who Perry Mason is?
No, I do not.
Oh, okay, but do you know Law and Order?
I do know Law and Order.
Okay,
yes.
See, so it kind of gives us a differentiation in terms of age, but a lot of times people consider every case that goes and is filed a Perry Mason moment, where people go to court and they actually see a judge, they have witnesses, they have evidence. But that's not true. Only 3% of cases too. So because of that, a lot of people don't understand that just having insurance in and of itself isn't going to cover you. So we get a lot of complaints. What are the complaints? I thought my workers' compensation was going to cover a sexual harassment claim. I thought my workers' compensation was going to cover my discrimination claim. I thought my workers' compensation was going to cover my unemployment insurance claim. And so because of that, I think it's very intelligent that Emory has given an opportunity to say that business insurance, as well as workers' compensation insurance, does not necessarily cover sexual harassment claims. So it's very crucial. But one thing, Emory, that you haven't talked about, which I hope you're able to elaborate on, is the issue of EPLI. Does KCAL Insurance have EPLI? Can you describe what it is?
Yes, we definitely do have EPLI insurance. Like workers' comp, it's required by law that you have to have that insurance as long as you hire an employee. But EPLI insurance is not required by law or anyone to have this insurance. So a lot of people fail to realize that this is another insurance they can actually consider getting. The EPLI insurance is called Employment Practices Liability Insurance. It covers anything that is not covered by workers' comp. So if it's work-related injury, it falls under workers' comp. It's non-work-related injuries such as sexual harassment, discrimination, wrongful termination. Those will cover under EPLI insurance. Of course, people thought, well, how do I get a quote? There's a basic application that we can actually provide you, and then you can complete, and then we will be happy to provide you with a quote.
Well, I could be able to say that EPLI, because I actually have it in my own business as well, EPLI is split into two main types that I see. One are non-wage claims, and the other ones are wage claims. And this is based on my own experience. So in getting a quotation, you may want to just make sure whether your EPLI claim covers wage claims or non-wage claims. I can be able to say, based on my own experience, that non-wage EPLI is very, very, very affordable. It is so affordable that I am stunned more businesses don't get it. Now, wage claims EPLI, they are more expensive. And the reason why is, as many people know in California, overtime, meal breaks, rest breaks, things of that nature, those are really big lawsuits. And so not every EPLI can be able to cover it. It is going to be more expensive. But let's just get an example in relation to EPLI for non-wage claims. Emory, I have a restaurant. We have 10 people, 10 waiters, maybe a couple cooks, maybe a total of 12 people. Can you just give me a range, an example of what I could be expecting on an EPLI where I haven't had any claims before, but maybe I have 10 employees, minimum wage employees with, a couple cooks. Can you give me a range of what I could be looking at over an extended period of time, maybe a year?
Well, a couple of years ago, EPLI insurance is a lot more affordable than now because insurance carriers have seen more and more claims coming in due to these losses. If you have around 10, 20 people, you're looking maybe about 5,000 to 8,000 in premium. Again, it really depends on your nature of business, your turnover rate. If you have a high turnover rate, the insurance company don't like the fact that you hire and then let people go just like that. Of course, insurance company will look at the fact that have you had any prior claims before? Do you have a potential current claim that might be an issue? Do you have an employee handbook? Without an employee handbook, most carriers will not offer a quote as well.
$5,000 to $8,000. That sounds like a lot of money, but I could be able to tell you that if you hire a law firm to defend you, you would at minimum be spending $5,000 to $8,000. And I can be able to tell you that if you're only spending $5,000 to $8,000 over the life of a lawsuit, you probably should be suing your attorney because he hasn't done anything on your case. And so with that being said, I think that EPLI is something that everybody should be looking at for their business. This is not an EPLI course. We'll talk about that in a different lecture. But I can be able to tell you from my own experience, it's better to spend that $5,000 to $8,000 or less towards your business now and have the insurance company's attorneys take over a case and do it for free than to hire your own attorney on the back end to be able to cover your sexual harassment claim. So that's my thought going in. And let's go over now the issues as it relates to sexual harassment. Thank you. Is sexual harassment relevant. You know, a lot of people say 20, 30 years ago, Mad Men type of situation, whereas way back when, obviously, sexual harassment was a problem. But not now. Of course not, because nobody harasses anybody in the workplace anymore. But let's take a look at 2009, in which the Department of Fair Employment and Housing presented its findings in regard to sexual harassment claims that were filed and discrimination claims that were filed in general. 17,680 complaints were filed in the state of California as it related to discrimination. As you could be able to see in the pie chart, you can be able to see the types of claims that occurred. But the interesting thing is this: the total amount of sexual harassment claimed filed in 2009 was 3,839 complaints. Now, the question is this: everybody knows numbers, but what really is the percentage? The answer is 22%. Almost 1/4 of the discrimination cases that were filed in the state of California with the Department of Fair Employment and Housing in 2009 is 22%. And that's an extremely high number, because it really shows that sexual harassment is relevant in the workplace. Sexual harassment still occurs. And this is not just with immigrant communities, this is also with mainstream communities as well. For those of you that are listening to the lecture, think about your work experience. How many times have people joked around about sex? How many times has one person hit another person on the butt? Just as a joke, but how many times has it happened? How many times have you been in a situation where you've seen one person stare at another person's breasts? The reality is, every person that is listening to this lecture can imagine that one time, whether you did it, whether someone else did it, whether it was to you, or whether you saw it, you have seen sexual harassment. And frankly, I think the 22% is very low. Those are the cases that were filed. In my opinion, close to 90 to 95% of every employee, every person that has ever been an employee that is listening to this video has seen sexual harassment in the workplace. Not just heard about it, but have seen it. Next slide. So what is a civil right? People think about a civil right as Martin Luther King on the street, screaming, saying we have a right to do something. But many people don't realize that sexual harassment, or to be free of sexual harassment in California, is also a civil right. So the right to work in an environment free from discrimination and or harassment because of one's sex or gender is a civil right. Now, the interesting thing is this. There are some laws out there that require you to be a U.S. citizen. There are some laws that require you to actually be here in the United States. But a civil right is something that just because you are here in the United States, it doesn't matter who you are, you should not be sexually harassed for any reason whatsoever. And I understand that a lot of people may roll their eyes and say, oh yeah, you know, I'm going to hear that, of course. But when I present the law to you for sexual harassment, I think you're going to be very shocked. And at the end, Emery and I will be talking. I'm pretty sure you're going to change the way you feel about sexual harassment in general. So there are several objectives that we're going to be discussing today. The first issue is one of, what is sexual harassment? How do you define what it is? 2, how do you recognize sexual harassment? I mean, it's an easy case if one person is staring at another person's chest, but what about if a person whistles? What about if a person just makes some comment, right? Are those issues of sexual harassment? The third issue is how to understand what the rights and responsibilities of both the employer and employee is in regard to sexual harassment. And the fourth issue is to understand what legal remedies there are. What legal remedies there are. Now, Emery, a few moments ago we talked about just 22% of cases that come in. Do you find that sexual harassment, or cases of sexual harassment? Are they reported also to KCAL Insurance as well? And what are the things that an employer can do in working with you if they hear of an employee where there is an allegation of sexual harassment? So let's go over the first question is, in your own experience, do you find that sexual harassment, still occurs in the workplace?
Of course, most definitely. I feel that a lot of times people don't feel that in those incidents it's considered sexual harassment, regardless if it's employee against employer, or employer against employee, or employer with the employee, or maybe it could be a third party listening to a joke and they feel offended. A lot of times they feel uncomfortable, but they don't see that as a sexual harassment. So of course they're not going to report it because they don't feel that they are being harassed. But perhaps in the long run, it comes down as to they feel uncomfortable. They probably need to perhaps bring it up to the employer or the manager's attention and say, hey, this bothers me. So-and-so perhaps made a remark, or I oversaw someone looking at some pictures that I feel uncomfortable, or making certain jokes. Those needs to bring it to the employer or the manager's attention immediately to prevent further actions or from further future cases of that same thing happening.
Well, the second question I have is, how can KCAL Insurance be able to work with companies? Is KCAL Insurance, if someone were to call and say, hey, I have questions about sexual harassment, we understand KCAL Insurance is not a law firm, but how can KCAL Insurance be able to work with clients or even non-clients in regard to sexual harassment and how to prevent sexual harassment?
We offer courses such as this, or sometimes we have a larger seminar that we hire, such as Cheng, to come and speak and educate our clients of what sexual harassment is and how to prevent that. Those are also available from KCAL.
Yeah, it's absolutely true. I know that I've been part of some lectures as well. They've been fairly exciting. There are a lot of people that come. They're exclusive, obviously, to business owners and the management team. But I'm very proud that KCAL Insurance has really taken the lead. It's one of the largest insurance brokers in Southern California for a reason, and that is that prevention for KCAL Insurance is so important to keep the employer from being sued. But Emery, are you going to be part of any of these classes that occur?
Yes, most definitely. A lot of times when those cases or seminars or lectures that we have, I'm always there to also participate and also assist any customer with any questions that they have.
So I've known Emery for a few years now, so I'm going to be giving her a hard time throughout. It's just purposeful, but definitely recommend Emery, as well as not just her services, but her knowledge in regard to the area, that you're more than welcome to call her. Just out of curiosity, is there a telephone number, an extension, if somebody needs to get a hold of you in regard to the sexual harassment claims or the sexual harassment insurance that we were referring about?
Yes. Our general number, which is very easy to remember, is 626-333-1111. But if you like to reach me directly, my direct line is 626-369-8801.
So, in terms of the objectives that we referred to, I actually have a trial on Monday in regard to sexual harassment. So I'm a little bit distracted, but let's talk a little bit about not just the objectives now in terms of what we're going to talk about today, but to define what sexual harassment is. So, what is sexual harassment? Sexual harassment under the California Code of Regulations, Title II, Section 7287.6, says that sexual harassment is an unwanted and unwelcome visual, verbal, or physical conduct that is sex-based or of a sexual nature. It's requests for sexual favors or offensive third-party conduct to which the victim is subjected. Now, one of the things that people joke about all the time is, can a person's eyes be sexual harassment? I mean, can a person just stare at another person and be sexually harassed? The funny thing is, there are some attorneys at the firm. In general, there's a joke that over the next 2 hours, attorneys that typically can't talk about sexual harassment, make sexual jokes in the law firm, can do so on this video. And that's what I fully intend to do. I just want you to know that. If anything, just to entertain the people that are listening. So I remember I was on the beach and I saw a t-shirt that basically says, "Stop making your boobs stare at my eyes." That's what it said, right? And it was kind of funny because I never thought about it that way. But the reality is that sexual harassment can be visual. Sexual harassment can occur with someone's eyes. And that t-shirt really is trying to make fun of something entirely different. But what it really shows is that sexual harassment can occur in the workplace, and under the definition, under the California Code of Regulations, it can occur with your eyes. Now, why do I keep on emphasizing that? Because of the fact that I can't tell you how many employers come to me and they always say the same thing. You can always look, but you can't touch. I hear that all the time. And, it's probably more with men than it is for women. And it's also more, I think, with more immigrant communities, because in immigrant communities, there's a lot of inside jokes. But people always say that. Well, I didn't touch her. I only looked. So, again, I want to emphasize about the visual part of the definition. Now, I would definitely say that Emery took a little bit of my thunder, because I think she said something earlier that was completely shocking. I didn't think she was going to say. And that is that third-party conduct. If you're a third party, that the sexual harassment doesn't have to be directed at you. It can be directed at somebody else at the office. And that if you're offended, you can actually be a claimant in a sexual harassment case. Now, why is that so important? It's so important because of the fact, and as we shall see, that a person claiming sexual harassment doesn't have to be the object of the sexual harassment. So earlier when I said, how many of you can actually remember sexual harassment taking place? I guarantee a portion of you said, well, it never happened to me. It never happened to me. And that's the reason why, because it wasn't directed at you. Well, I'd like to say that in this case, the sexual harassment did occur. Because if you were offended, you could have claimed to be in a position where you were sexually harassed. And that's under the California definition. Who is protected? Who is protected? Generally, all employees are protected. Now, there are a few people that aren't protected. Your parents, your wife, your husband, children. Those people aren't going to be protected. Independent contractors. Now, a lot of people say independent contractors shouldn't be protected. Why? Because independent contractors aren't my employees. They are people that come in and out of the business and they leave. They work for 1 hour, 2 hours, and they leave. I'll give you an example. Do you consider a person that comes in and works on your copy machine at the office part of your staff? Of course not. You don't do it because you don't feel they're part of your staff. However, many people don't realize that for sexual harassment cases, the person fixing your copier, the person that brings you water, even the person that brings you pizza, those are people that can claim against your business for sexual harassment. So this is very important. Job applicants. I cannot tell you how many disgusting cases of sexual harassment I've seen where an employer says, I didn't hire her. I didn't hire her. Well, yeah, you basically put out a job application for 100 people and harassed all 100 females that came into your business. So whether or not that person actually became an official employee is irrelevant. You can be able to you can be able to sexually harass people that merely applied to your job. Now, I'm going to be referring to a lot of pornography, believe it or not, over the next 2 hours. And the reason why is, in some ways, much of the pornography that you see online is a reflection of real life. And there's much pornography in online where basically an employer will put out an application, have the potential employee come, basically have sex with them and say there's no job. And you know what the funny thing is, that a lot of guys joke about that. They say, wow, isn't that the perfect way to sexually harass somebody? Well, the answer is no, it's not. And Forget about the fact that it's not right. The reality is it's against the law, because just because the employee didn't become, the potential applicant didn't become an employee doesn't mean you can get away with sexual harassment. Now, this is different from other forms of discrimination. So let's say that you decided not to work with someone because of their race, but they were an independent contractor, right? Let me give you an example. Let's pretend that you called up to somebody to fix your copy machine, and you could tell that they were a different nationality. So I'm Chinese. So let's say I called up somebody and I said, I didn't want to work with someone that's Chinese because maybe my Mandarin isn't so good. So the person's voice on the phone had a heavy, heavy accent. I decided not to work with them. Am I not working with them based on their race? Yeah, partially yes. But that's okay because they're not an official employee of my company. That's very different with sexual harassment. I can't say that they're not an official employee and therefore I can harass them. All right, next. Who is liable? Who is liable? This is also a very interesting area as well. So, Emery, I'm going to test you. I obviously have never thrown this question at you before.
Uh-oh.
But let's say that you were working for an employer, any employer, and the employer asked you to do something, and you were driving on behalf of the employer, and you got into a car accident. Now, it was purely work related. Whether or not the insurance is liable, but as a general principle, if you're doing something for your employer, is the employer liable for the car accident if it was your fault and you were doing something for the employer?
Yes, it will be. But this actually gets into, if it's a car accident, of course, a customer will ask, well, whose insurance will pay for it? Of course, I know this is off topic, but the vehicle of the insurance company will cover. But of course, since I'm driving on behalf of my employer, I can actually go back and sue my employer because I'm working for them and it's work-related injury. And also, my insurance company will pay for the accident and perhaps want to subrogate against my employer's insurance company. But that's off topic.
So basically, Emery is squirming and using big SAT words at the same time. But really, the general principle is that if you are doing work for your employer, that as a general principle, now you have to understand that Emery is very specialized, so she obviously has a lot of words that you may not have heard before. But as a general principle, the employer at least has exposure to protect its employee when it goes out. But the question becomes, what about sexual harassment? Well, here's the thing, is that the employer is liable at times, and the employer is not liable at times. So let's go over that. Government Code 12940, Subdivision J, 4, capital A says, any person regularly employing one or more persons, or a person that is hiring more than one essentially independent contractor, or a person acting as an agent of another, those are all people that can be liable. Now, why is this important? It basically means that as an employer, you can be liable more than you think. You can be liable for an independent contractor that does something for you. You can be liable for an employee when they sexually harass somebody. But the question is this in terms of who is liable. Employers are strictly liable for damages an employee incurs as a result of a supervisor or agent's sexual harassment. An employer is liable for a non-supervisory employee's harassment only if the employer knew or should have known of the harassing conduct and failed to take immediate and appropriate corrective action. So let me explain that. What is strict liability? Strict liability or strictly liable basically means if it happened, you lose. If it happens, you lose. So let me give you an example in real life. I have a Yorkie, a very small dog. It's probably about 5 to 6 inches long. It's very small. It's a toy, right? If my pet Yorkie, my smelly pet Yorkie, unfortunately, because for those of you that don't know, Yorkies do kind of smell sometimes, and nobody told me how cute this dog would be, but how smelly this dog would be, goes out and bites somebody, and that person bleeds, it does not matter how cute my dog is. It does not matter that I didn't have knowledge. I lose the lawsuit. That's what strict liability means. So if your supervisor, anybody in management, decides to sexually harass somebody, not only is the harasser liable, but the employer is liable too. Now, why is it that a non-supervisor, the employer is not necessarily liable for a non-supervisor? Well, the reality is that a company typically is very big. So my law firm is considered fairly large. However, I don't know what everybody else is doing at my law firm. So if the person that we hire just for photocopying on a daily basis decides to harass somebody, I need to have known or should have known of the harassing conduct, and I didn't take appropriate action. However, if one of my lead attorneys or my office manager decides to harass someone, I didn't need to know. It didn't matter. I would be liable for that conduct no matter what. So on any analysis that comes in, and even if you're a manager, because there are two types of people that are going to be listening to this lecture. The first one are going to be those that are owners of a business or the president or vice president of a business. They're essentially the principals of the corporation. And the second group of people are going to be the managers of the corporation, the supervisors of a corporation. Well, not trying to create a division, but again, I want to say this. For all of the managers that are listening, you have to realize that your employer cannot protect you if you've gone out and sexually harassed somebody, because we get this all the time where the general manager is going to say, wait a minute, this is just like a car accident. I accidentally hurt somebody like a car accident. My employer should be liable. It's no different than me delivering pizza to somebody and I got in a car accident. The law says, no, that is not the case. That is not the case. Your employer will be liable and you will be liable. And the employers also say that too. Wait a minute. Why should I be liable? I didn't know that. Well, that's the problem in California, is that employers are typically wrong. California has a very unique area of law compared to everybody else. And that is that employers are automatically liable if a supervisor is found to have sexually harassed the person. And again, an employer may not necessarily be liable for a non-supervisor's sexual harassment unless they knew or should have known of the harassing conduct and failed to take immediate and appropriate steps. So what is kind of new or should have known? Well, if you hear in the company of somebody harassing somebody, if you hear of one person feeling injured or feeling harmed, these are things that knew or should have known. There's another question people always ask me. But what about if there was a lower level employee harassing somebody else? Now, is the manager, because many of you are managers, I'm not going to get sued, right? I mean, I didn't do anything. I wasn't the one to harass anybody. Would I be sued? Well, let me tell you. One of the things that you're going to learn throughout this lecture, sexual harassment is just not your employer's problem. It's your problem, because more and more lawsuits are bringing in the managers, even though they are not the sexual harasser. Why? Because as a plaintiff, you can sue anybody over anything and prove your case over the life of the lawsuit. Well, many employees are saying, my manager knew about it, and my manager didn't do anything about it. And therefore, not only I'm going to sue the sexual harasser, I'm going to sue the manager, and I'm going to sue the employer. Well, let's put it this way. Many of the companies I represent, you know what we start doing? We start going and look at people's backgrounds. Not credit check stuff. That's nothing. I want to see if they ever got sued. Why? Because if they got sued, I want to know why. Well, as a manager, can you imagine you're working at a really good company? You're up and coming. You're somebody that's doing a really good job, and you get sued. And what does the complaint say? You know, in California, the complaints aren't verified. It's not under penalty of perjury. You know who writes those complaints? You know who writes those complaints?
No, I do not. Who does?
Attorneys. And you know what? Attorneys aren't the plaintiffs. So you know what they do? They write the most horrible complaints. Not horrible grammar-wise, but horrible where your face will turn red. I read a complaint where I wasn't part of the lawsuit. I didn't even defend the lawsuit. My face was red. Why? Because in California, there's something called punitive damages. And what are punitive damages? You know, the funny thing is, if you're Chinese, I don't know if you're Chinese, there are two things that you seem to know about when you come to Southern California. One, KCal insurance. Two, the McDonald's hot coffee cup case. Do you know the McDonald's hot coffee cup case?
No, I don't eat at McDonald's.
Oh my God. Emery, I cannot believe it. You have totally destroyed my presentation by not knowing the hot coffee cup case. But let me explain what the hot coffee cup case is. So during the 1980s, there was a lady, she got burned by hot coffee at McDonald's. Is that? Oh, see, Emery.
Now I remember,
see,
yes.
I'm telling you, when you're traveling, well, Emery, were you born in the States? Because I wasn't born in America. Were you born in America?
No.
Okay, so when we're traveling, right? So I came here December 25th, 1977. I was a little baby. I was laying on the ground, but somebody told me about this McDonald's hot coffee cup case, because I'm telling you, when you're growing up, everybody knows about it. So what do you know about it?
If I remember correctly, I remember it was a lady went to McDonald's and she ordered a hot cup of coffee. Then she accidentally spilled coffee on herself, and then because it was so hot, she sues McDonald's for punitive damage and for the injury. So I don't know if you're aware of now, a lot of beverage that you take right now, especially hot coffee or a hot beverage, the cup will automatically says, "Be careful, caution, hot," because of that incident.
And you know what the funny thing is, that we're not saying that the lady's case was not good, but what I am trying to say is that punitive damages, she got punitive damages, so she got hurt, and the damages were like very little. But at the time, you know, I think this was during the 1980s, she had like millions of dollars of damages. Now, we're recording right now in kind of the Roland Heights, San Gabriel Valley area, and you know, in San Marino during the 1980s, there were homes that were under $100,000. Did you know that?
I think back in the day, yes. Now, yes, unheard of.
Okay, so back in the day, she's basically saying back before she was born. So let me tell you, back in the day, I guess whatever day that is, that when I was young, there were homes under $100,000. Well, think about millions of dollars during the 80s. You could have bought 5-10 homes in San Marino. Can you imagine? You would have been retired by now.
Wow.
So with that being said, why are punitive damages so important? And, you know, attorneys just call them punies. We just say that we call them punies. Now, why are punies so important? Well, punitive damages, to be able to get it, just like the McDonald's hot coffee cup case, you need to prove clear and convincing evidence. You need to prove almost malice in the heart, almost sick darkness in the heart to be able to get punitive damages. Now, why was the lady able to get punitive damages? Because during her case, essentially, she would have had to prove that McDonald's had this intent, had this malice. Now, we're not here to talk about the McDonald's case, really, but what I'm trying to get back to is the main point. The reason why the complaints are written so that your face turns red is because of the fact that they want to show the malice. Now, you're a manager, and someone has said to you, whether or not it's true, that there was a person at my company and he told me to get on my knees and give him sexual favors, and my manager refused to help me. Now think about your next employer. Your next employer is a very big company, happens to be my client. You're coming in, you're going to be CFO, you're going to be vice president. This company may be going on the stock market. They want to hire some good people. What's the first thing they do? Well, if they're smart, they go to the law firm. They say, hey, we're going to hire somebody, really good guy. First thing I'm going to say is, well, let's take a look at the litigation background. Let's see, does this guy have forget about the credit, but does he have integrity? Well, next thing I know is I say, well, I'm sorry, ABC company. I wanted you to know your next VP, he was sued for sexual harassment. Well, the employer's going to say, well, obviously went to trial, right? Because they don't know, right? Obviously went to trial. He won, right? I said, no, it was actually settled. Well, can you tell me about the settlement terms? No, I can't because it's confidential, so we really don't know. Well, think about the employer that's going to hire you after you've been sued for sexual harassment, and it basically says that you can't even manage a person that tells somebody else to get on their knees to do sexual favors. Think about that. So again, sexual harassment is not a problem for your employer. It's also a problem for you. Can we take a couple minutes? All right, so we'll be right back. Thank you.